Call to order the January 8th, 2015 Board of Adjustment meeting. Our first order of business is to receive the minutes of the December 4th, 2014 meeting.
Move to approve the minutes.
Second. I have a motion and a second. Register your vote. Minutes are approved. Next is continuous requests by staff.
We have two today. Item number 8, case number 13982 is requesting a continuance to January 22nd, and item number 13, case number 13991 is requesting a continuance to January 22nd.
Is there anyone in the public that's here regarding either one of those cases? The first 8 and 13. Anybody from the public that's here regarding these cases?
I'd make a motion to continue items number 8 and 13 to the January 22nd docket.
Second.
I have a motion and a second. Register your vote. Continuances are approved. Are there any continuance or withdrawal requests from the public today? Hearing none, our next order of business is the consent docket.
We have 3 items on the consent docket today. Item number 1, case number 13987. Item number 2, case number 13986. And item number 3, case number 13989.
Make a motion that the items on the consent docket be approved.
Second.
Got a motion and a second to approve the consent docket. Register your vote. Consent docket is approved. Let's proceed to case number 4.
Item number 4, case number 13979, request of Hearst Holdings for a variance to the minimum driveway separation and to allow parking and maneuvering in the public right-of-way located at 100 West Main Street.
Do we have somebody here? If you would, just approach the podium and give us your name and address for the record and then address your application.
My name is Jeremy Gardner, architect with Bootser Gardner Architects. My address is 718 West Sheridan, Oklahoma City.
Want to tell us about your application and your request?
Sure. The application is we have 2 driveways that we're trying to introduce there on the Century Center site, one on the south along Sheridan, the other on the west along Robinson. And we're wanting to allow specified drop-off and parking for Opubco, which is the anchor tenant in that building, and then also drop-off and for valet at the new restaurant proposed there on the southwest corner of the same property.
Based upon the staff's favorable recommendation and seeing there's no opposition, I'd move to approve the variance.
I have a motion and a second. Register your vote. You're approved.
Thank you.
Thank you.
Item number 5, case number 13974, request of Benjamin Shulaw for a variance to allow a sign encroaching the street right-of-way located at 431 West Main Street.
Anybody here to speak to this application? I would entertain a motion to move it to the end of the agenda.
Moved.
Second.
Register your vote to move this. Okay, it's moved to the end of the docket. Case number 6.
Item number 6, case number 13980, request of Danny and Donna Van Dusen for a variance to allow a 2,400 square foot accessory building exceeding the maximum 1,838 square foot requirement and located forward of the rear wall of the main structure, located at 4417 South Westminster Road.
Please, sir, your name and address for the record.
My name is Danny Van Dusen. My living address is 14112 Shandale Drive, Newalla, Oklahoma.
Tell us what you want to do.
We're trying to build a building and what have you to the north of the house, and there's not enough property, and the property, the way it leans back towards my neighbors behind me, would shed so much water from the building and I don't have much room back there either. And that's the reason why I'm trying to build it over to one side.
You aware of any opposition from your neighbors, or?
No, sir. I have talked to a few of them and what have you, and they said there was no problem. I don't know about all of them, but
Okay.
Staff says the topography, the lay of the land may be a hardship. Can you explain that to us, please?
yes, sir. It slants aggressively towards the back of the property, and I don't know whether that's a picture of it there where it slants, and then my neighbors to the west of me, the water off of this building and what have you would shed so much it would just overwhelm them people even worse.
And those people are also in a flood zone, which we're not, but they are.
Right.
And it drops down about probably almost 7 feet down into their property. And if we put that building back there, it's going to cause all that water to go back into their property. But if we put it on the side, it's level beside our house. The pad would be level. It would not cause the water to be going back into the people's property.
It wouldn't be quite as aggressive and what have you too. It would slow that water dispersal down considerably by doing that.
And your neighbor's aware of these plans, and the neighbor does not object?
None of them that I have talked to and what have you have objected at all.
I'd make a motion to approve the variance.
Yeah, they sent letters out to each one of them, and none of them have said that it'd be no problem. Could they come over and talk to us?
We have a motion and a second. Register your vote. You are approved.
Do we need to reapproach for another permit?
What do we do?
I'm going to refer you to city staff. And
Call me later or call me tomorrow.
Okay, thank you.
Item number 7, case number 13981, request of Arcad Properties for a variance to the platted limits of no access to permit a drive onto May Avenue located at 15401 North May Avenue.
Good afternoon, David Box, 522 Colcord Drive, here on behalf of the applicant. We are seeking a variance to allow a new law office building being constructed to have access onto May Avenue. If you see the box that's highlighted on the screen, originally this tract was intended to be developed as a larger development project with the parcel to the north. It didn't pan out like that, and now we've got a standalone parcel with no means of access to an arterial. So we have a drainage channel to the south, so there'd be no way to access the south, and to the north is a already developed strip center. So in order to allow efficient means of travel by all parties coming to both the north parcel and this tract, we need access onto May Avenue. Prior to filing, we did meet with traffic staff, and they indicated that they had no objection, so we would ask that you grant the variance, and I'm here to answer any questions.
Councilor, the drive to the north that you referenced that was a part of the original development, are there cross-access agreements between those two parcels?
As of now, no.
No private agreement exists there?
Not right now, no. And that's part of our hardship is we don't want to have to rely on negotiating that possibly to gain access, because otherwise this parcel is landlocked. But we do, in reference to that access drive, we do meet separation requirements for access drives.
So this parcel was just carved out of the development, it was sold separately, and that's... Okay.
Correct.
I'd make a motion to approve the variance.
I have a motion and a second. Register your vote.
Thank you.
You are approved.
Item number 9, case number 13983, request of Aragon Properties for a variance to the conditional use regulations to permit a pharmacy located at 1024 Southwest 44th Street.
My name is Rod Baker, 2800 Northwest 36th Street. Here to represent Aragon Properties, who's the property owner. And our request is based on wanting to lease a small space in this office complex to a pharmacy. And we don't meet one technical requirement in terms of total square footage in a building, although it's a part of a much larger medical complex in the area. So it's a normal accessory use to this type of area. There's a large medical building to the east, and then across the street, of course, is the Integris Center.
Anyone in
Any questions?
opposition to this application for a variance that you're aware of?
I'm not aware of any. No, I haven't heard from anybody.
Based on staff's favorable considerations, I'd move to approve this variance.
Do we have some discussion, or Ms. Powers? We have a motion and a second. Register your vote. You are
Thank you
approved.
very much. Appreciate it.
Item number 10, case number 13984, request of Ross and Danita Herndon for a variance to the 5-acre minimum lot size and to allow 2 dwellings on 1 lot located at 7337 Southwest 134th Street.
If you would give us your name and address for the record.
Good afternoon. I'm Ross Herndon. This is my wife, Donetta Herndon. We're at 7357 Southwest 134th Street.
Speak to your application.
Yes, the property shown here has been in my wife's family as part of the Greater Family Farm for many generations. And upon the death of my wife's grandmother, it was deeded to my mother-in-law, this separate 2 acres, which has 2 houses on it. We currently reside in the small house shown here in the southwest corner of this 2 acres. So this property was deeded separately from the Greater Family Farm to my mother-in-law from my wife's grandmother upon her death. We since recently, last March, moved into this property. What we'd like to be able to do now, when these houses were placed on the property, was part of the Greater Farm. Currently, there's 160 acres to the north. We have lots of family in different residences around the area there as well. What we'd like to be able to do is some special consideration of variance to the regulation requiring 5 acres as a minimum lot size for a house in this area, so that we can, as they're already there, maintain those 2 houses and make remodeling, additions, or construction of another house in place of one of those houses on the property.
Any discussion or
So the
questions?
variance is primarily for the purposes of reconstruction in the future, is that what you're saying?
That's correct. That's correct.
Anyone in opposition to your application for a variance?
No, as a matter of fact, as I stated, many of the folks around us, the property just to the west is my wife's uncle. My brother-in-law is right down the street. My mother and father-in-law are right down 134th Street. And we've contacted everyone, the closest 10 to us, and we have no opposition at all.
Phil Scaramucci lives across the road from us, and he has a large section, and he was not in opposition either.
Make a motion for approval.
We have a motion and a second. Register your vote. You are approved.
Thank you.
Welcome.
Item number 11, case number 13985, request of Lynn Operating for a variance to the maximum height requirement located at 14701 Hertz Quail Springs Parkway.
David Box, 522 Colcord Drive, here on behalf of the applicant. This application, we're seeking a variance to the height requirements of PUD 302. That PUD is an older PUD from the 1980s in which it limited this portion of the PUD to 3 stories. If you're familiar with this area, you know that it's commonplace for there to be office towers in excess of 3 stories. We tried an administrative route to allow this to happen, and we weren't able to do that. But we do have sign-offs from the rest of the architectural committee as required for this parcel, and it's a fairly small variance. It's just from 3 stories to 4 stories. And so what this variance will do is allow an office building that will be in keeping with much of the other office buildings in this area. Staff have identified no unfavorables, and we would ask for your support.
Wrong thing. I have a concern about this application, not because I care whether the building is 3 stories or 4, but because I think that in matters where there's a PUD in place, the correct way to address these kinds of issues is through amendment of the PUD. And I don't think that we should encourage, get into the habit, I mean, whatever, fill in the blank there, of resolving these things this way. It is an old PUD, and for that reason, it probably needs to be revisited. But I really can't support the resolution of this issue through a variance.
I'm just saying, in this case, staff entertained an administrative amendment to the PUD, but there was some confusion with the developer as to exactly where the lines were, tract lines were in the PUD. So we approved an administrative amendment, but half of this tract is in the tract to the north, which required the 2-story height limit. So he's basically in compliance on, like, the south portion of the tract. But because of where the legal description was on the lines between the two tracts, it lapped over into the 2-story tract.
And to your point, Ms. Powers,
It met the requirements for administrative amendment on the south half of the property.
And normally, I would absolutely agree. But what we have here is a PUD that's so old that the regulations required as it relates to the height are really out of date, and they don't really conform to the way that this area has developed. And if we were seeking to make some major modifications to this parcel, then I would agree. But it's just one building, and I don't know that it would warrant an entire rezoning for 1 story. And as JJ said, it's a bizarre situation where essentially half of this would allow the 4-story, the other half wouldn't. And I don't know that it was a specifically negotiated item, and I know that that is what this board is primarily concerned with. If you've got a specifically negotiated item at planning through council, to come to this board and try to circumvent the process. And that's not what we have here.
Also, in this case, the building permit's already been issued based on that initial administrative amendment.
And there is that.
How about this? Based upon these unique circumstances, I'll move for approval.
We have a motion and a second. Register your vote.
Thank you.
You are approved.
Item number 12, case number 13988, request of Haley and Michael DiGregorio for a variance to allow a 1,440 square foot accessory building exceeding the maximum 1,250 square foot, the maximum height, exterior metal finish height, and pitch located at 2635 West Wilshire Boulevard.
If you would give us your name and address for the record, please.
Haley DiGregorio,
Michael DiGregorio.
and we both reside at 2635 West Wilshire Boulevard, Oklahoma City, Oklahoma 73116.
Pull that microphone a little closer, or step into it a little bit, and then tell us about your application.
This application is based on a variance. We are requesting a 2-story accessory building that will be deemed for a garage with storage area. The actual final goal is to knock down the house and build a 2-story house on the front portion of the lot. And obviously, until we can knock the house down, we need somewhere we can put our items in storage. After that point, it will go into a photography room. We're going to maintain the garage and have an arts and crafts room. At the moment, the front house is still 1 story, but we have just got the plans back for the 2-story dwelling at the front, which we didn't have at the time of the application.
While the board members review their information, is there anybody from the public, anybody in protest of this application?
I take it once the home's built, it will be 2-story and it will be flush with the other addition that you're here today.
Yes, the goal is to make them both architecturally look the same. So, Rick, even though the back accessory building will be built before the front building, when the front building is finally built, they will both look exactly the same. And from the
Can you
road,
kind of give me a timeline on the construction of both buildings?
based upon we were planning on breaking ground in February for the back building. If that happens, then 18 months for finalization for all of it to be done. We've obviously just received the plans, and we've approved the plans for the front building, and so we're just waiting on permits and permission at this point. We already have the funding and everything available to us.
Dan, what happens if we grant this variance and the home never gets built? I mean, then we're out of enforcement, and we have no...
The variance would still apply.
Well, we could limit it in time and make them come back to the 18-month, that's why I was asking about the timeline. Give them an 18-month variance and have them come back.
Well, what sense does that make? We're not going to make them tear the garage down.
That's what it's like. It's like it doesn't have any teeth to it.
It's really an act of faith between the applicant and this board that if we approve your variance and allow the structure to be built, that in good faith, you're going to follow through on your commitment to build a two-story home.
Yeah, the idea is that we're not actually going to build the back house or the front house until we're ready to go on all. The back house, well, the back accessory building will be built first, so that then we can move the items from the front house into the back house, and then the front house will be...
Is there an existing house there now that you're going to demo and
Yes.
rebuild on that same site?
Yeah, basically the house is falling apart, and so that needs to just be completely demolished and gone.
And you're representing to us that the funding's in place to do all of this, correct?
Correct. And I do have a copy of the front house architectural designs and things with me today, but I didn't have them when we submitted the application originally.
That's with the 2 stories?
The two-story, yes.
Yes, okay. Who's the architect, do you know?
Jeremy Meek has done the drawings for this, and then we've got a private person looking over them at the moment to make sure that they're all sound and ready to go.
I'd make a motion to approve the variance.
I'm going to second it somewhat reluctantly. I would certainly feel a lot better if the house were going up now. But I understand what you're saying, and I can certainly see as a practical matter why this makes more sense for the storage and all of that sort of thing. So I'm going to just cross my fingers and hold my breath. Second that motion.
We have a motion and a second. Register your vote. You are approved.
Thank you.
Item number 14, case number 13992, request of Catholic Charities Archdiocese of Oklahoma City for a variance to allow a sign located within the public right-of-way located at 1232 North Classen Boulevard.
Well, Matthew Radcliffe with Mass Architects, 18 West Park Place. Architect for the project here representing the applicant. We just have a kind of a wayfinding sign that we would like to ask permission to install within the right-of-way based on the rather large right-of-way in front of this property. We want to make sure that those trying to reach the building and the parking lot that is behind the building to meet some of the other downtown design concepts, if they miss the turn at 12th Street, then they'll have to do a U-turn because of the divided median on Classen. So we want to make sure that the sign can actually address the intersection while still being far enough away to not impede any side triangles.
I guess there's no one opposing
this?
No.
I'm sorry, does the staff report tell me anywhere how big the sign actually is? Or can you tell me how big the sign actually is?
The sign, I believe, is less than 7 feet tall. And it's, I think, about 12 foot wide. It's comparable materials to the building, brick with some cast stone, and then simple lettering.
This is kind of a unique area of town where we have a curve with a right-of-way, and this it will definitely be an improvement to this corridor of Classen, so I'd make a motion to approve it.
I We have a motion and a second. Register your vote. You are approved.
Thank you very much.
Item number 15, case number 13993, request of Lee Gross for a variance to the site-proof screening, landscaping, and hard surface paving requirements located at 3202 South Meridian Avenue.
Is the applicant here? If you would, sir, your name and address for the record.
I'm Lee Gross. My address is 10,500 South Harvey Avenue, Oklahoma City, Oklahoma.
Okay. Speak to your
I come before you
application.
to request a variance for gravel parking behind Enterprise Rent-A-Car, chain link fenced without trees. 2 years ago in May, with the tornado and torrential rains, several of us in that area got flooded out. I'm just completing a major 1,000-foot-long concrete drainage canal built by city engineering specifications through the property and other properties and dedicated to the city of Oklahoma City, known as the Gross Drainage Project. This should help eliminate the flooding problem to the whole area. The property behind Enterprise Rent-A-Car, that's about 1.7 acres, is now usable due to the drainage canal that we've put in. It's zoned I-2. Enterprise uses shuttle drivers to move cars between locations several times a week. The employees and the drivers and some new cars have been parking in that grassy area and along Southwest 32nd Street in that 30-foot road easement that was dedicated to the city. I would like to fence in the new usable area with access directly through the Enterprise property. All their employees and drivers would enter and exit through Meridian Avenue driveways. The fence would be a 6-foot chain link with no side gates. The only way in and out would be through Enterprise. This would eliminate unnecessary cars and traffic from the side road and solve a congested problem. Thank you.
All right, Mr. Gross, let me ask you to be seated. There are a number of people that have asked to speak regarding this application. Could I call Mike Lightsey? If you would, sir, just give us your full name and address for the record.
Yes, Mike Lightsey, 1014 South Lewis Lane, Mustang, Oklahoma.
Go ahead and tell us what you'd like to say.
Yes, sir. I've got 3 properties in the addition of Littleward Park. Has been in my family for a long time. We basically had built half of the addition. My concern is with everybody else living in the area, the screening would cause a dust problem in the neighborhood. I mean, we are downwind westward of that. And
the screening wood or the gravel wood?
Gravel, correct.
Is your neighborhood directly east of this lot?
Yes, sir.
Directly east? Okay.
Yes, sir.
So your main concern is the gravel and the resulting dust from traffic on the gravel and how it might impact you?
Well, the original application at Mr. Gross, we were all under the impression, the people that live in the addition, that he would be having gates and would be using our main thoroughfare through to Meridian. We would like for him to have to widen the road because as of right now, there is a lot of traffic from Hertz, Enterprise, that are just parking on the side of the road, and we have troubles getting out off of our street onto Meridian. It's dangerous.
Now, he's indicating that there'll be no access to that area.
That's been changed, correct.
So would that alleviate your concerns about widening that street? Since there's no traffic to that property except from that property on directly onto Meridian.
Correct, that has been changed. We just now figured that out. So.
Okay, so that's not an issue. The gravel dust would be your primary issue?
Yes, sir.
All right. Thank you very much,
yes,
Mr.
sir.
Lass.
The tract to the west where Enterprise is operating out of, the access to this vacant lot that you also own, that's where people are going to be making entry. They're not going to be using, looks like, I'm looking at an aerial from Google Maps, and it looks like they're kind of using a makeshift drive right now to get access to that. Can you address that so I'm clear?
Yes, sir. That area has just been a grassy field for a long time, and people have been parking and coming and going there. And I'm the one that brought this application in here to try to solve the problem of people going in and out of there and parking on the side of Southwest 32nd Street. I would like to fix that problem, and with the drainage canal in, to address the flooding issue with access only through the Meridian driveways. The cars would not be going in or out any other direction except through Enterprise Rent-A-Car. There's a 30-foot gate in Enterprise Rent-A-Car over the concrete drainage canal. The drainage canal already has the top on it, and that's where the entrance and exit will be. It will not be on 32nd Street.
That drainage canal runs in between what I'll call your east track, which is the grass, and the west track, which is where the rent-a-car place is operating.
Yes, the drainage canal is directly behind the east side of Enterprise Rent-A-Car. It would be in the middle of this whole track where the cars have been parking. And that's why I wanted to get the variance to solve the problem and brought this to the attention of everybody. So I want to get the cars off of my street back where they belong.
Thank you. If I could ask you to
Yes, sir.
be seated again. We've got one other party.
Before you take it, let me ask you, what is your main objection to actual site-proof screening between you and the
Okay, I'd like to
residents?
answer that if I may, please. It's kind of difficult, but over the years, there have been a lot of some thievery in the area. Tires have been stolen, batteries have been stolen. I feel like with the chain link fence to let site be open, that would cut down on that. Several times I have asked cars that are parked on Southwest 32nd Street on the easement what they're doing there. Twice it's been law enforcement with binoculars watching that area down there. On Southwest 31st Street, there's, as you'll probably know, a lot of vacant houses have been moved off and some boarded up houses. And I hated to block in the area. I don't mind putting up a stockade fence, but I thought for security for the neighborhood and for us and everybody else, that should be open so the site plane could be visible.
So it's a security issue.
It is a security issue, yes, sir.
JJ, can you address, the vacant lot is zoned I-2, correct?
Correct.
And I-2 allows for chain link fence, correct?
I-2 allows for chain link fence, except
When it abuts.
when it abuts a local street across from residential.
So that's the basis for needing the variance there, is because it abuts the residential
It's
area.
across from residential, correct.
Is there any opposition here today to the chain link fence?
Actually, we've got one more party that has requested to speak. May I allow them to speak?
Okay, thank you.
Mr. and Mrs. Rakestraw, you've asked to speak. Would you just give us your name and address
I'm
for the
Maylene
record?
Rakestraw. We're at 4239 Southwest 32nd Street. We're not necessarily opposing to him doing this. Our biggest concern was the flow of traffic, which, I mean, he's obviously addressed that to this point today, saying that he was going to not use the back exits. As of right now, they do use those back exits. They don't use Meridian, and I provided photos, and on some of those photos, if you look at the intersection going on or off of Meridian from 32nd Street, there is no way to have two flow of traffic, and that's been our biggest concern.
And I think that's what he's attempting to remedy by, the variance request to allow it to be fenced. There would be no...
We're okay with that, if that's the case. However, he does own the property just south of Enterprise on the other side of Southwest 32nd Street, which is Advantage Rental Car, and they do use that back exit every day, all day, for their transportation of passengers for the rental cars back and forth to the airport. So that's constantly an issue. There's no side.
And I will tell you, that's not a part of what we're going to hear today. What we're going to deal with is the variance request before us. What I would tell you, though, is I think Mr. Gross is interested in being a good neighbor and a good steward of the property and the areas that he owns.
Right, and that's why we're not opposed to him.
So that would be a separate discussion between you all privately. But today, So the fence would be, complete, there'd be no gates, so there'd be no traffic except onto Meridian.
There would be no problem with that with us at all, except for unloading the vehicle. They use the 18-wheelers to unload the vehicles. And what about going over that bridge from where the drain is on the back of that property?
We'll give Mr. Gross an opportunity to respond to that concern of yours.
Okay.
Thank you very much.
Thank you.
Mr. Gross.
Yes, members, I'd like to address a couple of items. I know it's not relevant, but as to Advantage Rent-A-Car, yes, they do use a van and a bus. When the new Conrack is completed on Meridian, the massive parking facility, Advantage Rent-A-Car will be gone. They're moving out of that location. It'll go back to the Hertz, which services the airport, the FAA only, or mostly, and there will not be a problem there. That is a done
again,
deal.
that's not our issue today. And
Yes, sir.
I think, just, having a good relationship between you as a property owner and the...
And with the owners, I would like to meet with them if they, I'm there on the site almost every day where they're permitting, and I would like to get a petition up to see if we could get a major street put in there, as well as I would like to see, there's no fire protection down there. I would like to see if everybody would get behind me to go to the city and see if we could put in a fire line with fire plugs for fire protection.
And I'm sure that they would all appreciate it.
That's something I need their help with.
Yeah, let's address the gravel and the potential problem with dust for the adjacent neighborhood.
Directly to the north of me, it's Basin Environmental. I don't see that a problem. Directly to the south of me, it's me. The houses are far to the east. I see no problem with the dust.
Well, you've got an adjacent neighborhood to the east.
Yes.
And normally the wind blows from the north or the south, but not, always. And I can understand their concern about a gravel yard that would generate a lot of gravel dust when, vehicles are driving upon it. I think there are gravel surfaces, too, that are less likely to create that dust.
Gravel or crush and run. We could use crush and run, which turns back in.
JJ, in the past, we've looked at the composition of the gravel to keep the dust down.
Yes.
And I don't remember the specifics of what that was.
There are some options in the code for gravel. Certain uses in I-2 do allow gravel. This doesn't happen to be one. So we do have specifications in the code. There's 3 or 4 different options.
Okay, so what's the best for keeping dust down?
Probably...
Don't mean to put you on the spot.
Crusher run.
Crush and run.
And a commitment to water as needed to keep the dust down.
Mr. Griff, have you ever looked into asphalt millings or something that's a comparable cost to crush a run?
No. We have 3.2 acres of concrete now at Enterprise, and economically, after the drainage canal, gravel would be the best way to go. And with Enterprise being there, they will not allow dust, I promise you, on their cars. So it would have to be crush and run or something like that. There would not be a dust factor.
Let me ask this. For the gentleman that objected to the dust, can you come back up here for a second?
Mr. Lightsey.
If the application was amended to use this crush and run and to make a requirement that periodically we water that to keep the dust down, is that something that would satisfy you?
Although I don't live in this neighborhood, me personally, I really don't really have a problem as long as it's up to code. Crush and run, which I'm familiar with, would be suitable, yes.
Another thing, board members, before we proceed, we do have a petition for people that were in opposition, and they addressed the street widening issue as their issue. And, you might indicate whether you're satisfied as to whether...
That, to me, issue goes away if this fence contains the flow of traffic onto Meridian. So if we do that, in addition to the crush and run, we have probably, I know it's not in our purview, but we've probably preempted any type of nuisance claim that could arise from this variance. So with the area being contained and contingent on the gravel being the specification of crush and run, that would eliminate their concern as far as a claim of nuisance and tort, which I know is not above us, so I would be willing to support those elements in factor of of a variance.
Is there anybody else from the public that wishes to speak on this application?
There is one thing, if you don't mind, I would like to bring up to this.
Okay.
That's really not mentioned here. Years down the road, if they want to put lighting up, there's houses within 20 feet of that area. It's just going to get real bright in the neighborhood. If that's me, totally, I'm against the lighting of this. If there is a lighting plan.
The city has a fairly strict lighting ordinance.
Yes.
That prohibits spillover light on adjacent properties.
Okay.
They have different options for lighting, but it has to be contained on the site.
All righty. Thank you.
Thank you, sir. Any other discussion or questions? I would entertain a motion. Yes, sir.
My name is Marvin Rakestraw. The only concern I have is the 18-wheelers that are on Meridian, unloading the cars. When they're unloading them, we cannot see getting, onto Meridian, which causes a factor of anyone turning in and, trying to get in or out of there. So will this bridge that he's going to build over to will accommodate 18-wheelers to unload the vehicles for Enterprise?
That's not really a part of our business today, but I think it's a fair question to ask Mr. Gross. So you're saying when the trucks pull up on Meridian in front of their property to offload cars, that it creates sightline issues when you're trying to turn onto Meridian from Southwest 32nd?
Correct.
I would ask council or staff whether this is something we can discuss or whether that's something that privately you may need to discuss.
I had a sign put up that no 18-wheelers years ago because they were actually pulling on 32nd and unloading.
I think the ruling here is going to be that that's not a part of the application, so it's not part of the business before us today. But I think, Mr. Gross has indicated a desire to be a good neighbor, and so I would, talk to him. And nobody wants sight lines obstructed so that turning onto a main thoroughfare is dangerous. Right. Thank you, sir.
Oddly enough, the issue doesn't seem to be eliciting any commentary from our guests today. The idea of this property not being site screened is concerning to me. This kind of a use is, a pretty significant commercial use, almost a semi-industrial use, and for it to be adjacent to a residential area and not be site screened at all, I think is problematic. Although it is not the first time I have heard a business owner raise the issue of security with respect to closing off, completely enclosing anyway, a yard like this. I think I personally would prefer to see that east property line fenced with something that provides visual screening. And perhaps I would suggest at least that we put some time limit on the variance that would permit him to put up a chain link fence, so that if it becomes an issue in a year or 2 years for the neighborhood, that we'll have some ability to address it at that point.
I think I share your concern with the balancing act between the safety issue and the screening and landscaping requirement, but why don't we just conditional use it as long as this is used as a rental car deal? Wouldn't that help too? I mean, this is a pretty common for security, as long as this business purpose is that way, they're not coming back here until their business use changes. Well, it satisfies, I mean, I think asked them to, I just have ever since I've been on this board, which is, I guess, almost 4 years, I've always leaned towards public safety concerns and security issues from one of the very first cases I voted on like this. So I think that the security interests and the theft, in my opinion, is more balancing than the compelling interest for screening. And I get why you want these cars contained within a chain link environment and why what he could do to the top of those would secure the perimeter. So I'm very sympathetic to what you're saying, but I would rather him be able to protect his employees and the cars than have some type of theft element out there.
Janice, is your concern the no side screening from the neighborhood to the east? I think, one thing they might be able to do is go ahead and put the chain link in, and you can put the screening material in the chain link, and perhaps, screen the east side, the north-south run on the east side of the property. That would provide screening, of the property from the neighborhood. Mr. Gross.
I have no objections to putting a stockade fence on the east side. The cost is very nil compared to a good chain link fence. I brought that issue up only because of the problems in the past, because we'll be secure. I worry about the people on the other side if we block them off. I thought that was an issue to help the people in the neighborhood. That's all.
No, I don't hear your neighbors complaining about it, so...
Also, just for clarification, can you tell us how tall the chain link fence is?
Be 6 foot.
Okay.
It's a delicate balancing act. You've got, but we don't have any opposition from the neighbors, so I'd make a motion to allow the chain link fence, as long as this is used as a car rental facility based on the crushed rush gravel grade.
I want to be sure I understand your motion. Your motion is to require crusher run, and in addition to that, to require access only from the west piece, not off of Southwest 32nd Street?
Yes, sir.
I'll second that motion.
Yeah, just indicate there would be no gates or no, egress or,
The only gate would be about a 5 or 6 foot gate for the lawn people, and the city would also require a gate to be able to mow on the drainage canal, but I think it's a 4 foot requirement. And cars can't get through 4 foot.
Before you second that, could you also add to the crush and run to periodically water as needed to keep the dust down? Would that be okay, Nick?
That'd be a question for Mr. Cravens.
Yeah.
So I've got a motion and a second.
Yeah, all right.
Just register your vote. You are approved, sir.
Thank you, sir.
Item number 16, case number 13997, request of United Engines Manufacturing for a variance to the 25-foot platted front building line located at 9900 Northwest 2nd Street.
Good afternoon, Tim Johnson on behalf of the applicant. This is a request to vary the front building line of a plat that was filed a long time ago. The initial, as you can see by the drawing, the initial thought was when West Hall development was developed, the street was built to here. It was always thought that it would continue. The street was built to here, but then the development, we hit a sag. It never occurred. Now the properties are owned in different entities, so vacating the plat is much more difficult than just varying the building setback line, which is shown here in red. The right-of-way will continue to be used for a drainage channel that has been approved by the city to be installed, and that work is underway. United Engines currently owns this tract, and they're going to expand and put, they own this tract, and they're expanding their building here and putting in the channel and putting their parking out here. There's a different owner that's getting ready to develop here, so this property is beginning to move finally after 20 years. And so we request your approval on the variance to the building line. You can see the size of the building here, just clips the building setback line, not the easement.
You anticipated my question about the plat vacation, so because this is a somewhat unique situation, because it is in single ownership, and we're talking about a single use here, I'm going to move for approval.
I'll second.
Have a motion and a second. Register your vote. You are approved.
Thank you.
Item number 17, case number 13995, request for use variance of Trey Resources for permit to drill an oil gas well located at 13905 Southwestern Avenue. And Mr. Box needs to make a statement before.
Yes, sir.
Mr. Chairman, Dennis Box and Bob Gum and David Box are here. We actually represent the property owners which are in protest this case, so I'm not up here to speak for the applicants. But there's a pending lawsuit with our client, and it's between our client and the City of Moore, separate piece of property, has nothing to do with this. But Mr. Stonecipher's a lawyer for the City of Moore, and although he's always been very fair and understanding on all these cases, I think just the appearance would probably dictate that he'd have to recuse in this case. So I want to just make sure the record was clean.
I would agree with that.
Good afternoon. I'm John E. Lee III. I represent Trey in this case and the following case, which are basically combined or should be combined for these purposes.
Danny, are we allowed to consolidate number 17 and 18?
Yes.
Okay. So let's just hear them as one case, if that's okay, Mr. Chairman?
That is, if it's acceptable to the other board members.
Okay.
Please proceed, sir.
Trey is before this board seeking a variance, what turns out to be a residential zoning, to drill 2 wells as operator of the West Shore Junction Unit. This particular tract is located in the northeast quarter of Section 20, and it's on the far east side of the West Shore Junction Unit. What Trey intends to do is to drill 2 directional wells from Section 20 westward to drain oil and gas for the benefit of the West Shore Junction Unit owners from respectively Section 17 and 19 and 20. Trey has had its application for permit to drill for both of these wells approved by the Corporation Commission and are ready to go. The surface owner is the protestant Shaz Investments. We have filed a petition under the Oklahoma Surface Damages Act because we were unable to negotiate a surface damage settlement with Shaz. That's been on file for some time, and as this board undoubtedly knows, under that particular statute, Title 52, Section 318.5, once the petition's on file, then, at least under Oklahoma law, the Trey has the right to move on. Now, certainly Trey does not have the right to move on without the approval of this board as a variance to the zoning, and that's why we're here today. Trey, as the operator of the West Shore Junction Unit, has a statutory and fiduciary duty to the royalty interest owners, the other working interest owners, to develop the hydrocarbon reserves. It turns out that there are very few surface locations within the bounds of the West Shore Junction Unit from which Trey can develop or drill wells to develop the east side of this unit. That which we have sought is before you as would represent basically the minimum use of the surface to develop these resources. Now, Shaz has filed a protest in which they claim there's other places, but I would submit to you there's not. The hardship on Trey as the operator of the West Shore Junction Unit is failing a variance, then they're going to be deprived of developing the hydrocarbons, producing the hydrocarbons, reducing the hydrocarbons underlying the unit boundaries in the Hunton and Bartlesville to possession for their royalty owners. It covers some 33 sections. Every drop of hydrocarbon that comes out of these two wells would be shared by every royalty owner in the unit, as was the other working interest owners. And so Trey has that obligation as unit operator, both statutorily and at common law. Failing the variance, they're deprived of it. That's the hardship. I believe that Trey's been before you before over in section 22 of 10 North 4 West, and we have the final item on your agenda today is an application for a disposal well in that particular tract. Trey's been before this board before for three other producing wells for variances to in this same area, all of which have been granted, which should have been granted and have been granted. Trey has commenced operations on one of the wells contemplated by the first variance, and everything's going according to plan. I'll be happy to answer any questions. I appear before you with Mr. John Stromberg and Mr. Dave Minyard, both of who are engineers. Mr. Stromberg is a reservoir engineer who can speak to any concerns you may have about the development from these particular locations, the optimum spot to exploit these reserves, and Dave Minyard is basically in charge of the operations overall and can speak to the well design or the direction of the well, the completion practice, whatever. These wells will be drilled, I can represent you, these wells will be drilled directionally, basically horizontal, extended lateral lengths. They will not be fracture stimulated, and there's a concern about that. There's also concern, I guess, raised about being in a seismically or earthquake-sensitive area. We have received word from Charles Lord, who is an individual with the Corporation Commission whose area of responsibility includes this sort of thing, and as I'm sure you're aware, the Oklahoma Corporation Commission is actively studying and monitoring the seismic events in Oklahoma, and as if to determine whether or not any of the seismic activity is related to activity in the oil and gas business, in particular disposal wells. There'll be no disposal wells in these particular tracts. And there has been some notions afoot that some seismic activity, tremors, earthquakes, could be related to hydraulic fracturing. There's not going to be hydraulic fracturing of these two well bores. We'd ask that the board approve these two variances so my client can proceed forward.
Thank you. At this time, Mr. Box.
Do you want to take protest?
I actually would like to hear from Mr. Gann if he would like to speak first, and then if you would, sir, your name and address for the record.
Alan Gann, 5400 North Grand Boulevard. I'm here I'm wearing four hats today. I have surface properties nearby, two commercial pieces of property, and then there is a tree farm that I'm going to build my personal home on. So that's three pieces of property. I also own minerals under this Grand Junction unit. So I'm here in favor of Trey Resources. I'm asking you to grant a variance. Because in my point of view, having those wells near the properties to be drilled there is far superior than what is going to take place if they don't drill it. Furthermore, if the development has been presented, when the process was going through by Shaz, they were very much in favor of oil and gas operations. So the oil and gas operation was there, the unit was there, and the position was that, yeah, it's fine, we're going to coexist. They didn't have any problem to be neighbor with oil and gas operations. Now they're doing 180 degrees. So there is that inconsistency and hypocrisy there. I also want to mention another factual issue in Mr. Box's opposition that was presented. He's bringing a close proximity to a school. This school has been closed for 5 years, and is an abandoned building, and is going to be demoed. In fact, it's in the Shaz or Home Creations applications. So for those reasons, as a surface owner, property owner, I'm totally in favor of Trey's issuing variances, and mineral owners, I definitely want them to drill it. In fact, I feel like it's their fiduciary duty to drill it, because I don't buy minerals just to sit on it. I want them to be produced so I get economic benefits. You don't give them variances, I'm going to be deprived on multiple fronts. So I am asking you to grant their variance.
Thank you, Mr. Gann.
Any questions?
Thank you.
Did I understand you to say that you're an owner of minerals related to this application?
I am under mineral owner under the unit, yes.
Oh, okay. Thank
Yes.
you.
Yeah.
Mr. Box.
Mr. Chairman, members of the board, a couple of things. It's very rare that you'll see our law firm objecting to cases, and I want to make sure the record's clear. The last speaker indicated that our position was 180 degrees contrary to our position we took at the Planning Commission. As Ms. Powers will note, for the last 2 years we've been dealing with plats, we've been dealing with development, and we've always said that the operator, whoever that might be, and at the time we were dealing with Roland Tegg, who represented a trustee. We're now dealing with Trey, but we do not take the position they're not entitled to drill. We're taking the position that this site that they propose for you all is not an appropriate site. They actually have 2 sites existing on the property, and they could develop off either one of those sites. So when Bob Gum and David Box get into the details, I want to make sure that this commission understands our position is not contrary to what we've discussed with the Planning Commission. Our position is what they're asking for is not the least necessary. It is not appropriate. It's too big. They have 2 existing locations, and that's where they should be asking this board to drill. So with that, I'm going to turn it over to David. We also have Bob Gum, who is very involved in the oil and gas industry, both the Corporation Commission and in litigation. And then we have an engineer that we think will show that there are other locations, 2 that exist, that are appropriate.
Thank you. David Box. The engineer that we have is named Terry Brittenham. He's a petroleum engineer. We have hired him to review the applications filed by Trey and analyze not only this particular piece of property, but the entire unit that Trey has the rights to mine the minerals. I hope everyone has a chance to read not only the justification letter submitted by Trey, but also the brief that we submitted. I want to show you a couple of these exhibits. A lot of the exhibits are coming around. Over here on my far left represents the entire unit that Trey...
That's this packet?
Yes. That represents all the property within the unit that Trey has the rights to drill based on their position as operator of this particular unit. And if I could just highlight so you have a scale, our quarter section that we're dealing with is right here. As you can see, it's on the complete far eastern side of the unit, and you can see the size of the unit, and you can see throughout the entire unit there is a substantial amount of undeveloped land. There's a substantial amount of industrial land. This board will be aware that they recently granted Trey a use variance, and it was over here on Meridian in the middle of an industrial zoning piece of land. And fortunately or unfortunately for Ms. Powers, she has sat through the last 2.5 years of zoning and platting that has gone on this piece of property. I do think it would be of benefit for the rest of the board to get a brief summary of that. When we started out on this piece of property, it was October of 2012 when we first met with the neighbors. We had the entire 120 acres planned, and we had residential, we had apartments, and then we had commercial on the frontage of Western. We faced a lot of protests from the neighbors, and back then even from the oil and gas operators. When you look at this particular exhibit, not only does it lay out the various platted sections that we have, but it's got a series of red boxes. And I want to explain what those are. The red box that's down here, that would be towards the southwest portion of my client's property, that is a current pad site operated by Trey. It's approximately 2.5 acres. It only has one well drilled on it. This pad site right here is another pad site currently owned and presumably operated by Trey. They have a third tract up here with tank batteries and other operations. So we then took portions of this out and we went through and zoned just the residential portion. Again, Trey protesting us the whole way. We then added back the second piece and had another zoning application. Trey fought us all along the way. We then did the commercial. Trey fought us all along the way. And then we went through the various steps of platting the entirety of this property. At all times, saying, we understand we have the rights to develop the surface. Trey has the rights to develop the minerals. We understand we all have to work together. We're not here to say that Trey doesn't have the right to drill and develop the minerals underlying this property. They do. But they can accomplish their goals in current pad sites on this property, on current sites within the West Shore Junction unit, and what this board is charged with is applying the statutory standards that any applicant has to meet in order to receive a variance. If you've had a chance to read the brief, you've read the Walking Stick case and the Vincent case. What they both stand for independently is the applicant has the burden of proof. The applicant has the burden of proof to meet each and every element. Not 3 of 4, not 2 of 4. Each and every element independently must be met in order for a variance to be granted. There's going to be a lot of information we're going to present, and I ask you to bear with us, but each piece of information you're going to receive is tied to one of those 4 elements. I'd like to address just a few of them before I turn it over to Terry Brittingham. When we look at the hardship element, their justification letter, and counsel explained that the hardship is if the variance is denied, they won't be able to extract the hydrocarbons. Well, he didn't say why or how. He just said, I think he said, I will submit to you. Well, we're going to be able to produce evidence from a petroleum engineer that they can extract the same volume of hydrocarbons that they're seeking to extract with these 2 variances from other places within the unit, but also the 2.5 acre pad site that they already are using and have excluded my client from on this very piece of property. Now, he did say that these 2 places are the optimal spot for them. Again, if you've read the Walking Stick case, it says added advantage or added convenience is not a hardship. It might be easier, but that's not what this board is charged with protecting. They've got to actually have a hardship. Nothing within their application, nothing that they have told you today is a legally recognized hardship. Next, there's got to be something peculiar about this piece of property for there to be a variance. Their letter made no attempt to satisfy that. I don't believe they said anything previously that would satisfy that. There's nothing unique about it. There's nothing peculiar about the 2 spots they seek when you consider they already have 3 separate spots in operation today. Next, we have to focus on whether or not the application would be a substantial detriment to the public good. Now, normally, the actions of an applicant have no relevance to a zoning case. But when you're dealing with the public good, we believe the way an applicant has operated in the past has a significant bearing. We have a stack of complaints filed at the Corporation Commission, and additionally, you have another protest letter that was submitted independently of us from a neighbor in Tuscany that will tell you Trey is a bad operator. They don't answer phone calls. They don't properly maintain their well sites. And the stack of papers and the evidence will show that. And so we do think that's important to take into account when you're considering dropping wells right in the middle of a 400-home subdivision. And finally, the minimum necessary. Now, what Terry's going to highlight later is what they can do with horizontal drilling and modern technology, the amount of well sites you can have on small pads. Again, this pad over here, approximately 2.5 acres. Terry's involved in a pad site on 104th and May, not far from here, in which they have, I believe it's 5 or 6 holes drilled on a pad site almost the same size. And here, they're seeking, I believe, over 7 acres for 2 holes. That is excessive. There is no way that that is the minimum necessary. They didn't try to tell you it was the minimum necessary. They haven't filed anything to say it was the minimum necessary. They simply alleged it. But what you're going to hear is unrebuttable evidence that you can drill everything they're proposing. They're only proposing 2 holes here. All of those holes, plus more, could be drilled on existing sites. Again, we're not saying they can't drill. They have the right to drill on this property. What we're saying is they can't meet the statutory conditions they are forced to meet to get the variance. They can drill those holes right there. And with that, I'm going to allow Mr. Brittingham to address his portion, unless there's any questions of me.
Go ahead, sir, and pull that microphone down a little closer and give us your name and address for the record.
My name is Terry Brittingham. I office at 4200 Perimeter Center Drive. I live at 10065 Hidden Hollow Lane in Oklahoma City. I'm a petroleum engineer, licensed to practice in Oklahoma. I have particular experience and expertise in developing oil and gas properties in urban areas, especially Oklahoma City, over 35 years. I started at the airport and worked out from there. I've drilled, completed hundreds of wells, planned and operated those wells with my clients and with my own company. I'm familiar with the Short Junction unit and in its historical operations. I've reviewed the applications by the applicant to drill not only the 2 wells that are being proposed on the subject property, but the disposal well that is a very necessity, or of necessity, an integral part of the drilling of these 2 wells. I've inspected the property. Summarily, I've concluded the applicants are asking for too much. They can drill both these wells from one pad. We'll start there. I can give you an example. Southwest 104th between Portland and May, right on the northeast corner of Early Wine Golf Course. In the mid-'80s, we drilled 6 wells for Monsanto. They're producing there today. So, and that's give you a drawing of that. That's approximately just slightly over 3 acres, 360 feet by 370 feet to drill 5 wells. At a minimum, these 2 wells can be drilled from one pad. Moreover, they can be drilled from the existing pads. There are 2 existing pads in the south half of the northeast quarter of Section 17, both of which would accommodate 2 additional wells. But more importantly, the 2 wells that are proposed to be drilled are horizontal, as Mr. Lee pointed out. Their surface location is located approximately here. The trajectory is generally to the west. One of them, they're about 900 feet apart, the surface locations. One of them is designed to be drilled about 1.5 miles to the west, northwest. The other about 1.5 miles to the south, southwest. Now, that is designed to drain, if you will, the unitized formation in that area. My review of the area shows that there are also alternate sites off of the subject surface lands wherein the same reservoir can be developed. There's a site immediately to the due west of the proposed tract. There's a site in the southwest corner of Section 20. There's a vacant site in the southwest corner of Section 18. And in fact, which might be from a reservoir engineering standpoint cheaper and better exploit the minerals.
Before you go on, I'm sorry
Sure.
to interrupt you. I hate to acknowledge this out loud in public, but I'm in way over my head here. Are these arguments about whether this is a better site than others relevant to our decision-making?
It's relevant to whether they have a hardship.
Okay. Are these arguments about whether or not they should be drilling someplace else arguments that would have been, could have been, should have been made to the Corporation Commission through that process?
I'm not
You don't know?
familiar with the Corporation Commission process, but typically they're addressed on the variances here.
We're here. This is us. Okay, I'm sorry. Keep going.
That's right. Those are fair questions. The Corporation Commission doesn't deal with surface accommodation issues, unfortunately. So I've identified at least 3 areas to the south and to the west of the proposed surface locations.
I'm sorry. Your comment hurt. So when you're saying that there are better places, are you talking about strictly in terms of the extraction of the minerals, or are you talking sort of the mixed package, that it would be better in the sense of it being less disturbing to the environment and they can get the minerals they want?
Both. You have to have your cake and eat it too.
Okay.
I want to ask another question. I want to piggyback on that. So you're saying that in oil and gas drilling's a probability that the alternate sites you've suggested not only don't affect the residential, but also would have the same probability of producing the same amount of hydrocarbons as the sites they've selected?
That's correct. The horizontal laterals intersect and drain from the very portions of the reservoir that would be drained by the proposed laterals.
So
this is nothing more than a large underground French drain.
The same formation would be economically, it has the same economic viability of being at the same level produced, in your opinion, based on your suggestion as an alternative to what they've suggested.
That's right.
That's a fair statement?
I see no material detriment. That's correct.
Thank you.
Sir,
Go ahead.
sorry. Then presumably you understand the other side of it. You said you've drilled hundreds of these wells yourself, correct? Or you've been a part of that?
That's right.
So what would compel them to want to do that if it were in fact easier and better to do it another way?
Nothing related to the extraction of oil and gas. And in fact, I mean,
There could be
wouldn't
no
you
argument.
want to just build one location instead of 2 if you could?
Right, but
These well sites are going to cost them $100,000.
so it would be your position that there's no reason for them to want to do this from an economic standpoint?
Certainly not from the exploitation of the oil and gas reserves, no. Mr. Lee brought up the concern about seismicity, so I'll touch on that. This is a special reservoir. It's been out here under development for almost as long as I've been alive. The technology it's been water flooded. All the oil and gas was produced out that would originally flow out and produce out by itself, and then water was injected, filled up the reservoir until it reached close to an economic limit. Now the proposal, as I understand it, is to put in a large subsurface French drain and produce back all the water out in hopes that economic oil and gas will flow with that. Well, that requires high volume, high rate saltwater disposal capacity. Ergo, the proposal to drill a disposal well in Section 22 to the Arbuckle, much like the facility at Southeast 39th and Bryant, the Dominion facility. There are known faults that penetrate the underground formations in this area. They've been known since the time of the development of this field. Certainly. These are faults, these big blue lines are big fault lines. And those are the concern of the Commission and deep earth disposal, high volume, high rate disposal. And seismic studies can only it requires a seismic study to see whether or not disposal is going to be a problem with these faults. Are we going to have increased seismicity or no effect. I haven't seen any seismic study. Furthermore, these, let me go to this one. As each of these laterals is drilled and completed, I know Mr. Lee said, maybe it's a stipulation, that these wells won't be hydraulically fractured, won't be stimulated. But if in fact they are stimulated, I've seen some concern in the record about the mechanical integrity of these 50-year-old wells in the field, that perhaps they don't know where all the wells are completed. These wells were drilled at a time when the Garber Wellington wasn't as protected as it is today. Most of the well bores that are plugged and abandoned in the area of the northeast quarter of Section 17 have surface casing set shallower than the base of treatable water that the applicant has identified in his applications by several hundred feet. So if water were to get away, we have an exposure. I haven't seen any evidence of a study of the mechanical integrity of the wells that would be affected by the production. And maybe there'd be no stimulation, but that would have to be a stipulation, because that would be unusual for these type of wells. And with that, I'd entertain any questions.
Well, Mr. Lee needs the opportunity to respond. Mr. Box, is there anything else from you?
I do have one question for you. I can't help being a lawyer a little bit here. Your qualification in response to his question about, would there be any reason that would prompt them to do this, the qualification that, not related to the hydrocarbons, is there any reason that you can think of why they want to do it the way they want to do it? I mean, is it less expensive? Is it just
It's inconsistent with the development of the West Short Junction oil and gas reserves, if there are any. It might be consistent with other development.
And that's probably a question that Mr. Lee, deserves the opportunity to respond to.
I can address real quick, and then I've got a couple more issues with Bob Gum. What we have found in the over 2.5 years that we've been fighting Trey is they have a hope of a much larger scaled project, but they're not ready to do it. And my client, owning the surface, has the right to develop it. And they now feel the sand slipping through their fingers. They don't know what they want to do, but their only hope is to just block off as much as they can so that hopefully someday it is possible to drill. And so that's the only reason that we can think of that it would happen. My friend Bob here has a saying where he says they want to be the dog in the manger on top of the hay. They won't let the cows eat the hay, but they can't eat it themselves. And that's what's happening here.
Counselor, are you offering up that one of the reasons to do this is essentially some form of monopoly for them? Because to Janice's point, I'm a little ignorant about that. By expanding that pad site, is that extending their reach in some way?
What they'd like to do is to push us out as many places as possible. So they've got the rights so that in some day in the future, they can drill more holes.
On those sites?
Correct. But unfortunately, as you know, the burden is they've got to show why these two wells, irrespective of some grander plan, meets each and every one of these variance requirements.
I understand.
And with that, I'll turn it to Bob. He can tell you if I got his saying wrong.
You probably got it wrong.
He's been practicing. I'm Bob Gum. I live at 406 North Gregory Road in Tulsa, Oklahoma. My office is in the Hightower building. I've been an oil and gas lawyer in Oklahoma City for 37 years. I've been involved with the protestant here and dealing with Trey for the last 2.5 years. I'm quite familiar with most everything that's going on that surrounds this application. David has asked me to share some thoughts, and I have agreed to do that. I have tried to organize them in a way that would answer questions that I think I would have if I were sitting in your chairs. that might not otherwise get answered. It's going to put me a little bit out of order, but I detect considerable interest in why Trey would do what they're doing, and I will explain that as I proceed with my remarks. But basically, Mr. Brittenham's surmise and Mr. Box's statements are correct. I know from conversation with the principals at Trey that they have a long-term potential plan of establishing a very involved central location that would at one point house up to, I've been told, over 20 wells in this part of this development and all of its attendant mechanicals. I think it's a long-term plan. Maybe it's more than a pipe dream. I know they have legal problems because Western Avenue to the west that borders my client's property is the legal boundary of the unit, and they cannot exploit hydrocarbons east of that legal boundary using their unit facilities. So there's problems. This ties into the three main points that I'd like to make with you today, and I'll entertain any questions as we go. It won't mess me up. I want to make the point that any hardship that you can see that Trey would suffer if these applications are denied, that hardship is self-imposed, and I will explain. Secondly, as Mr. Brittenham suggested, and I will verify through Trey's own lawsuit filings, that there are very questionable conditions, mechanical conditions, that Trey itself has alleged that affect the old well bores in this unit. Trey does not know by its own allegations in a lawsuit it has brought against the predecessor operators of the unit. Trey is in the dark as to where they have perforated the well bores illegally in these wells over the years, creating a potential for communication between zones, behind casing, in the angular space, creating the potential for communication, as Mr. Brittenham suggested, uphole into the fresh water zone that exists out here. There are a lot of water wells out here. My client has one. It's actually, that water well, if I can point to it right here, is actually located inside this requested area that they have picked for their northern spot. Your ordinances prohibit another oil well to be within 300 feet of that water well. They may not have known about it. It's in a water well building when they filed their application, but it's there. These issues that are raised about the mechanical integrity of their old well bore pose, in my opinion, my experience as a well-experienced oil and gas lawyer, grave concern about what happens, about their ability to predict what happens when they start carrying on their new operations. And this is true whether they fracture stimulate these wells or not. I am concerned that that problem is there. I'm also concerned about the problem of seismicity. As Mr. Brittenham has pointed out, there are well-identified faults that are featured in this area. They're stable today, have been as far as any of us know that are in this room. I know there's a lot of talk and public discussion about seismicity induced by the oil and gas business. Don't get me wrong, I'm proud to be a representative of the industry. I'm well aware of this issue. I'm the unfortunate lawyer who's been hired to defend the industry's position on this point in the first case that's been filed against it. It's in the Supreme Court right now. I watch, I look every day at all the new information. I have to admit the evidence is there that the disposal well that's been proposed, the laterals that have been proposed, under the right conditions, can spawn earthquake swarms. under the right conditions. My concern is I have heard nothing from the applicant in this case to indicate that it has sought to study the seismicity risk associated with what it proposes to do today. One of your jobs, as I understand it from talking to Mr. Box, is to make sure when you're granting a variance that you don't invade the protections of the public safety that were originally built into the no-drill ordinance here in the city. I view it as Trey's obligation as a good representative of the industry, as a good steward of this area, to come before you and present to you confirming evidence that what it's about to do is not going to pose a risk of seismicity here. I haven't heard it do it. That's a problem for me as an oil and gas lawyer. These aren't the 70s. These aren't the 80s. These aren't the 90s. This is 2015, where every operator, and I represent a lot of folks just like Trey, is now aware that it's a potential cause and effect between what it poses as by way of its operations and these earthquakes. It is a new world where you have to look at this. And I haven't heard that Trey has picked up on this and has elected to take steps to try to protect the public's interest in safety. Trey is, because of its quest to maybe someday have this kind of a bicycle wheel looking affair of all these wells going out from a piece of property. It has sought to basically keep my client from developing this residential development. It has elected over the last 4 years to seek, basically to create a set aside for who knows in the future possible oil and gas activities. I will tell you as an oil and gas lawyer, the rights of the oil and gas company to make use of the surface outside of your province to regulate it here in the city is a right that you can lose if you don't use it. You're not allowed, just as David said, to assume the position of the dog in the manger, because at some point in time you're saying, well, I might want to use that. If the landowner's ready to do something with it, you got to recognize that. Trey should have, but did not recognize that 4 years ago. It could have brought these applications to you 4 years ago. It would still have faced some issues, but I submit to you that the character of this land has changed. 4 years ago, it was undeveloped. It is not now. It is finally platted. My client's development is well under construction. Had this been brought to you at that time, I submit it would have looked different. Troy elected a different route. They wanted to try to force this set-aside. They did it by fencing in these 3 areas that are still fenced in on my client's property that Mr. Brittenham says they can easily use to do what they need. They've already taken it. Why take some more? They did that. They tried to fence in another 40 acres, and we just tore that fence down. They filed 2 lawsuits. We've had 2 lawsuits. They came in one night while we were all in court and had 7 bulldozers out there plowing everything up. All this stuff has gotten them nowhere except 2 things. They're under a cease and desist order by your city, and they're under a temporary restraining order from the district court down in Cleveland County for approaching this improperly. Do it or get out of the way is the rule. And they've decided to do it too late. The character of this place has changed. In your pile of papers, and I know there's a whole pile of them, are 3 things that I brought to the room. I'm told by Mr. Lee they're not going to fracture stimulate these wells. That does relieve one concern, if that's in fact the case, and I don't doubt John's statement to that effect. I'm sure that's what he's been told. But I'm also sure he doesn't know. He's just been told that. I don't know how these things are going to be economic if you don't fracture stimulate them. The first piece of paper I brought to you, since I look at this stuff, or my staff does every day, is a New York Times piece from yesterday, where in the state of Ohio, the authorities there have studied fracture stimulation and have concluded that wells within 1,000 feet of the fault cause earthquakes. And if you look at this crude drawing that my partner and I made where these two wells are going to run right here, and if you look where this fault bisects the subject property, you see we've got two horizontals, basically railroad tracks. Now, even if it's not fracture stimulated, I can tell you from my experience in litigating this stuff that the loading or unloading of fluids from those rocks can affect seismicity. For this to be successful, as Mr. Brittingham has stated, they're going to have to repump thousands of barrels of fluid out of here that weighs a tremendous amount. And this is one of the leading theories that the scientists are pointing to have concern about seismicity. This needs to be evaluated before you're asked to finally okay this. There is no basis to risk a wrong result at the cost of these landowners out here when it's Trey's job to bring it to you to show there's no risk. They haven't done it. My suggestion that there's problems with the mechanicals of their well bores is not just dreamed up by Bob. They filed a lawsuit, and I've included a copy of it in my papers, wherein they have sued their prior operators alleging these problems with all these rogue perforations and their lack of control as what's going on downhole. And they've sued them claiming that it poses a danger. And I submit to you until they get that problem resolved. That's being litigated at the Corporation Commission, I hear. I've seen the pleadings. The people they accuse of having done that have stood up and filed things saying we didn't do it, show us your evidence, in the meantime shut all these wells in. There's an uproar going on this point. Right now, with you, you've got to decide today what you're going to do. Is it ready today? I submit it's not. The final thing I brought is a collection of things that I pulled out of the Corporation Commission's records. And I want to build the record as saying that I'm not criticizing Mr. Lee, and I'm not criticizing Trey for personal reasons. But what I see in this collection, these are complaints filed by landowners over the last 10 years with respect to Trey's operations out in the country where they have not minded the rules. Out in the country where it's not nearly as sensitive as it is in this residential area that they're proposing these operations. These are problems of not cleaning up their mess, not plugging their wells. Just that kind of aggravating thing. They haven't killed anybody or anything like that. They've had leaks. And in each of these instances, they haven't stepped up to do their business. The regulators, the landowners have finally got the regulators to force them to do it. And I submit those stripes don't change very easily. I have clients that have these same lapses, and they may promise to come to Jesus today, but I'm right there defending them again in 6 months. It's a matter of economics. It's hard to do a good job and make a profit in this business with what I'm going to call leftover projects. I think Trey is faced with that here. This lawsuit they filed makes it clear to me they bought a pig in a poke. And they bought it at $100 oil, and it's $50 oil now. I cannot imagine that if they can't do their business out in the country where you're a long ways away from somebody's home, but they're going to do a better job with far more sophisticated type operations in a far more sensitive setting. I can't imagine that they can pull that off. And I think that too goes to this problem of, do we have a public risk? I don't know how they'll do. I know I've watched them in the last 2.5 years here in this thing. I know there are some things that strike me that show that their practices aren't changing. They've got one of the wells on my client's property, the one in the southeast corner, it hasn't produced in 30 years, and yet it's not plugged. We've been careful not to cut their pipelines. It's been a problem because although your ordinance requires they be 4 foot below surface, our x-rays show they're 2.5. So when we cross them, we're having to add dirt to basically make their pipeline legal at that point. These are the kind of things that you don't want to invite into a place like this. There are opportunities for people like Trey, but I don't think, from my perspective, this is one that you should allow and expect it to be a good result at the end of the day.
In order to keep this hearing timely, I think we've made our points, and I appreciate your testimony today. Thank you. Mr. Box, anything else before we let Mr. Lee respond?
Just one brief point, and it gets back to what Ms. Powers and Mr. Cravens had asked as to why. Ms. Powers, you'll remember at every Planning Commission hearing we have said all along, we understand they have a right. And their big complaint was that we showed lots over their existing sites. And you heard me at this very podium say, those are just placeholders. At such time that the oil and gas operations are done, we can then build a house. So what did we do? We went and finally platted and started building where they don't have operations. And what has Trey done is come in with an application and proposed this well right on top of a finally platted lot with streets already paved. And that furthers their ability to just push pause on everything. And they can't do that. And so in closing, I would just ask this board to follow those strict statutory conditions. And I would submit that they have failed to meet all of them. But even if you disagree, if they fail to even meet one of them, knowing that they have the burden, this variance cannot be granted. Thank you very much for your time and your patience.
Thank you. Mr. Lee. Did I see a hand go up in the back? Okay. Pardon me, my mistake. Mr. Lee.
Bob's great, as usual. I know Terry. We worked together 30 years ago. I'm a petroleum engineer, too. I guess I fancy myself as a petroleum engineer that happens to practice law. Let's go through the best I can about where we can and can't drill. We have filed a response to the Shaz protest today. I have attached as an exhibit to it a plat that speaks to the Section 20, Section 17, Section 18, and Section 19, and we call it a bubble plat. And it has been generated by Trey to show where there may be a spot to put a surface location that would not impact the 300-foot radius around dwellings, or I'm sorry, warehouses, 600-foot radius around dwellings. And I know you can't see very well from there, but there isn't very many spots. Now, this does not include the platted areas of Shaz. They are here in the northeast of 20. Everything else is existing. So our spot to put a surface location for any well is limited. Not only that, and again on the exhibit you can't see very well, are shown are 2 contemplated wells. or the paths of the two contemplated wells along with surface location. You can see that, contrary to that which is Shaz submitted, these are the paths that are permitted. The 2101, which starts in the northeast corner of 20 and goes, basically is drilled to the north and east to capture reserves in Section 17, and then is planned to traverse across the southerly part of 17 over into 18. 2102, basically same area. It is, the directional plan is to drill south and a little bit east, and then back to the west to capture reserves underlying Section 20 and Section 19. Mr. Briddenham and others have spoken to other locations within that they think are open. Well, yes, we agree. But we have future plans for future development. In order to capture the reserves for the working interest and royalty interest owners in the unit, we will need to put additional wells whose surface locations will probably be in the south part of Section 19, the southeast portion, the southwest portion, potentially over in Section 17. What we're before the Commission today is saying this is where we need to be for a variance to develop the reserves to be captured by these two wellbores. That is shown as Exhibit A to our response.
Can I ask?
Shaz's protest,
Mr. Lee?
Yes.
Is what you just said that there are other places that you could drill, but you want to use them in the future for something else?
For additional wells, ma'am.
Okay.
These wells are not the know-all, end-all for the development of this particular West Short Junction unit. We're in the, I wouldn't say preliminary, the early stages of, as Bob alluded to, of Trey's plans. Contrary to his assertion, it's not a spider web. It's not a bicycle wheel, not spokes. It's an orderly engineered plan. To the law. They being Shaz, cite walking stick to you. Walking stick has no place in this matter. Walking stick is a case about Amoco. That's the only thing that's common. It's an oil company. Has nothing to do with the mineral estate. Amoco wanted to drill a test hole on their research facilities in Tulsa. Number one, walking stick's a notice case. They didn't give proper notice. It is also I guess you'd say a hardship case, because it concerned a building. There was a building requirement in Tulsa that they had to put their well under. Doesn't apply here. It's not an oil and gas case. And as you know, and I've told you many times, and as you well know, notwithstanding Mr. Box, Mr. Gumb's representations to you, the mineral estate is superior to the surface estate, always has been. This unit has been in place since the 60s. Shaz came in 2012. Their deed to the property is subject to right-of-way. I don't know that we've made an exhibit, but...
I'm going to interrupt you real quickly with a question. That assumes that the surface rights owners have no real development opportunities in perpetuity. If you said that the mineral rights, in essence, trump surface rights, what you're telling them is that the surface rights holders, don't have any opportunity to develop because... Am I understanding you correctly?
No. That is not so, Commissioner. No. What I'm saying is that the mineral owner cannot be deprived of its right to develop the minerals because of surface use. Now, they coexist, and the Oklahoma legislature has modified that blanket assumption, or blanket block of law about the superiority of the mineral estate by the Oklahoma Surface Damages Act. They have said to oil and gas operators, no, under oil and gas lease, oil and gas law, you can use so much as the land is reasonably necessary and an oil and gas lease, no matter what's there. Well, that's been trumped by the Oklahoma Surface Damages Act. There has to be some sort of real compensation to the surface owner for the use. That's oil and gas lease law. What we have here now is Oklahoma unitization law that even makes the use of the reasonable use of the surface even of higher priority because it's a body politic. This unit has been in place for a long, long time. Mr. Gum says, well, we've got a well that's been produced in 30 years. Well, maybe not, but the well is still a unit well and still a usable unit well. And there is no provision, and he can't cite you one, that says the well needs to be plugged under Oklahoma statutes or under commission rules. It's within the unit.
What seems more pertinent to me was his observation about the fact that the development in that area is significantly different today than it was 4 or 5 years ago. And, your position seems to, be that would preclude them from the development that they're pursuing and the right to pursue that development. And I think his observation that if we had heard this 4 or 5 years ago, when that area was undeveloped and there were no imminent plans for development,
well, that might be right, Commissioner. But when Shaz bought this property 4 or 5 years ago, they certainly had constructive notice of the unit. They had the declaration of the unit was in place. There was existing wells, our 173 and 174, which you've seen before, are right there.
I don't think they're arguing with your right to recover your minerals.
Okay.
What they're saying is that you have existing pad sites, and why the need for additional sites? Why not utilize what already exists to recover the minerals that you have ever
And again, I would refer you to the plan of development and the way, notwithstanding what Terry Brittenham said, we cannot, from any different location, we can't drill an east-west lateral. No matter what he says, we can't. It's impossible. We have to start in the northeast corner of Section 20. And that's why we're here, and we're entitled to. We're entitled to use the reasonable use of the surface as unit operator. We're asking the city to sanction that by granting us a variance to the zoning ordinance. That's it.
Councilor, what you're showing us there, you stated that is a map that shows where you couldn't locate a new well that wouldn't be within the separation requirement, correct? Those yellow bubbles.
Yes, sir.
Okay. And so now that same exhibit demonstrates that there's an opening where you're proposing to locate the wells. Is that correct?
And that opening includes the Shaz platted area.
Understood. What your counterparts on the other side have said is that your existing sites could accommodate the extraction of those minerals and that the use of that is not necessary to accommodate that extraction. So irrespective of those yellow dots, that you could locate on those existing pads and accomplish the same thing. Is your position different than that?
Yes, it is. It's completely different. The existing...
We have not ever seen that. Do you have a copy?
Yeah, I'll give you a copy.
Has it been filed with the city?
Yes.
No.
To address your question, Commissioner, and I don't know that I have a plat with me that shows the location of the two existing wells, the 173 and the 174.
Here they are.
Right, and you can see that the 173 and the 174 are not amenable to the plan that we're trying to accomplish from drilling from the northeast corner of section 20. The 173 and the 174, we're trying to drill them up here. In order to capture the reserves that this well will capture that is to going north, we'd have to drill a very long lateral north and then try to curve it back west. That is, Terry may disagree, but I have engineers here with me that say that that is not feasible from an engineering standpoint. Same thing is for the other lateral that is to traverse the southerly part of 20 and into 19. If we drill from 174 or 173, again, we'd have to drill north and then turn around and go back west. This is the optimum way to get those reserves. Plus, the radius of drainage, and again, put my engineer hat on, the radius of drainage around these laterals is more or less elliptical. And so, in order to capture the reserves that are located below the ends of the laterals, the terminus of the laterals, we're going to have additional wells, which we will attempt to accommodate the surface location by these other open areas. That's the plan of development. Now, hardship, again, the hardship which is visited upon us is deprivation of the rights of the mineral owners, Mr. Gann included, to reduce the hydrocarbons to possession. And I would cite to you to the Vinson versus Medley case, which was decided after Walking Stick.
Let's go back to Walking Stick for a minute, because I have a question on that.
Okay.
I know the fact pattern's different, but I take away from this, being on the commission, being on the Board of Adjustment, that Walking Stick holds that all four requirements of 11 OS 4407 must be held for a city Board of Adjustment, municipality over 200,000 people, to apply to approve a oil and gas well. Do you don't disagree with that, or do you?
I don't agree with that as far as you state it, for any variance. To get under a 407 variance, there are four criteria, yes.
But you don't agree that all four of those criteria have to be met?
Yes, I do.
Okay.
And that is re-articulated in Vinson versus Medley. And where the court states, and again, this is paragraph 6, in a proper case, the board is empowered to make an adjustment and grant a variance from a city zoning where its little enforcement would create unnecessary hardship or prevent a constitutionally permissible use of the property. Our constitutionally permissible use of the property is to develop the hydrocarbon reserves beneath it.
Is that under our jurisdiction?
Well,
sure it is. No, I'm asking the municipal councilor.
I think what the Vincent case stands for is that total denial of somebody's right to exercise their mineral estate is a hardship.
Exactly, Commissioner.
They cannot totally be denied their right to exercise their mineral estate.
So is it your position that you would be completely denied your ability to extract the mineral estate if this request is denied? Is that your position?
I think that overstates my position. My position is that failing this variance, we would be deprived of extracting the minerals that are capturable by these two well bores as contemplated to drain the reservoir. Yes.
My interpretation is that it doesn't deny him access to the mineral reserves. What it does deny him is the easiest and least expensive and most expeditious access to the reserves, and that's the reason for the request. Not that they're not accessible another way. It's just not the easiest, least expensive.
Well, again, Commissioner, I disagree with you to this extent. It's the only way. Now, if we were to use the surface from off-site, go across Western and drill under Western, we don't have the right to do that. We don't have the statutory or constitutional right. We do have the statutory and constitutional right to develop the surface over our reserves. So it would be physically possible, I guess, to drill a well from another surface location and drill it horizontally to capture these reserves. It's possible. Now, if that's what you mean by this is cheaper or more efficient, then that I
Well,
can
and I think just a moment ago, you illustrated to us, what the other option was for you from the pad sites that are already existing to capture your minerals. At this point, let me excuse you, and if you would like for your engineer to have the opportunity to testify, and if not, I'll invite Mr. Box and any of his representatives to respond.
Can I have a second?
Yes, sir. Board members, Mr. Harris has asked for a 5-minute recess. Any objection? This hearing is recessed until 3:35.
Commissioners,
One moment, Mr.
Okay,
Lee,
sir.
and we'll officially reconvene. As a matter of fact, we will go ahead and reconvene this Board of Adjustment meeting, so please. Yes, sir.
just a couple things, Judge. Bob talked about seismic studies and seismicity and possibility of tremors and that sort of thing. Attached to our, and that we haven't conducted a seismic study, attached to our response, and as I referenced it to you before, the Corporation Commission has a staff that studies this stuff. Attached to our response is an email I received from Charles Lord, who says, and I'll quote from it, yes, and the materials I filed earlier.
I don't believe the board has those materials, sir.
They're in the clerk's office.
Did you file it with our office? Or when?
Yeah, but I filed it, I think, around 1 o'clock or 12 o'clock today.
So we were already gone.
Yeah, you were. I inquired to Charles Lord. My client, Trey Resources, operates the West Shore Junction, Bartlesville Hunting Unit, located in portions of 10 North 4 West and 10 North 3 West of Cleveland County. Trey intends to develop the unit by drilling additional wells in Section 22 of 10.4 and in 20 of 10.3. Trey also intends to drill a new non-commercial disposal well into the Arbuckle in 22 of 10.4. Charles Lord, who is the person who is responsible for keeping track of the seismically sensitive or earthquake-sensitive areas for the Corporation Commission, emailed me back, John, there does not appear to be any seismic activity as of today that would prevent your client from obtaining a permit to dispose. He goes on to say, please advise your client not to drill into the granite, and if they do, they'll need to set a cement plug at TD. They also need to be prepared to show good proof, gamma ray mud log, that the well is not in hydraulic contact with the basement. If you have any questions, give me a call. The guy that is in charge of this gave my client the green light. I don't see any reason for my client to undertake a so-called seismic study. Secondarily, Mr. Gumbs, what I think, he's not an engineer. And for him to represent to you, as he is an engineer, that removing fluid from the Bartlesville Hunting Reservoir is going to cause earthquakes because there's faults in the Hunting is just not sound science, and it's not based on anything except his allegation. Insofar as a stack of complaints that he says are Corporation Commission complaints, I'm here to submit to you. I also checked with the field inspectors. Well, in all candor, I was employed as a judge at the Corporation Commission for a number of years. I'm very familiar with the Corporation Commission personnel. I had contacted the Office of General Counsel and the Field Inspector's Office as it pertains to the West Shore Junction Unit and Trey. I was informed that there are no complaints filed by the Commission, and any complaints that are filed by third parties have been deemed non-meritorious.
Can I interrupt you at this point? Sure. Several board members have expressed an interest in hearing from your engineer.
Okay. And that's, spent too much time trying to address the other side, but I would present to you Mr. John Stromberg.
Thank you. Welcome, sir. Would you give us your name and address for the record, please?
I'm John excuse me. I'm John Stromberg. I live at 138 Deer Creek Road in Edmond, and my office is at 63rd and Rockwell in Bethany. I am also a licensed petroleum engineer. Been practicing for 50 years. I've drilled several of these wells. I'm not sure exactly what your concerns are about what was said, but the one thing is oil reservoirs are not lakes. They're basically, oil is found in what looks like solid rock. So we don't have huge drainage areas. So, as Mr. Lee indicated, we drain elliptically along that lateral. So if you move that lateral, you move your drainage area. I'm not saying there are not other areas to drill, but to drill these laterals in these particular areas, we need to start as the commission has approved. Now, as Mr. Gum indicated, we do have additional drilling prospects, and there will probably be additional wells drilled parallel to these, because these wells do not drain large areas. They will drain maybe 330 to 600 feet each side of a lateral. So when we're scattered over a half a mile, we may have to drill 2 or 3 more wells along this same area. So yes, we could drill a well in here, but we still need these spots to drill these laterals to recover these reserves.
Can I stop you right there?
You may.
Would it be your position that those reserves could not be recovered in the manner with which your opposing engineer has illustrated, that existing pad sites that are already in place, that these same reserves could be collected? Is it your position that's not possible?
I have not seen his map to see which positions he indicated, so I really can't address that.
Trey has existing pad sites.
There are some wells out there that are pads, yes.
That serve this formation, correct?
Yes.
And it is possible to drill multiple wells from one pad site, which allows for extraction of these oil and gas hydrocarbons from all over the formation, hypothetically, correct?
We can drill wells, yes, from a site, and we can, within reason, reach distant areas, yes.
And are the existing pad sites within reason, within reach of these reserves you're trying to extract?
Could I see one of their maps? Because I didn't ever see their maps. What is the scale?
You know how far it is from... Terry. You know how far it is from this existing north side?
That's right. This is one side, this is another side right here. They're about 900 feet. These are about just a little bit less than 400 foot square. So instead of drilling up like this,
I don't believe that we could drill this one from these two. It might be possible to drill one of these from that one, yes.
So it is in fact possible in your view?
It's possible for one of them. I don't believe you could drill both of them, no.
From the 2 locations south?
Yes, because the 2 locations south are basically the same.
What about from the location that exists in the northeast of the subjects at issue?
This one, we could drill a well across the north side possibly.
Okay.
these two we could drill and cover the south side. But they would not be exactly the same area that we have with the existing wells, and of course I'm not familiar with those pads at all.
Is there anything else that was said that you feel like that you should refute on behalf of your client that specifically pertains to that?
Well, basically, I'm a reservoir engineer. I'm not a drilling engineer. So I'm really the wrong person to be asking some of those drilling questions. As I said, the thing that I would refute is I need that lateral placed in that spot to recover those reserves. And we do wish to drill additional laterals because those two laterals will not basically drain those 4 sections. We will have to drill additional wells to drain those 4 sections. So consequently, this is just the first step. We just drilled a well west of these wells. And so that's starting to create our plan. We need these two to further create our plan. And then we have also other wells that we are already planning to drill and are in process of drilling.
When did this plan come into existence?
Well, first of all, Trey has only owned this unit for a short time, since about last summer. So 4 years ago, we didn't have the right to do any of this. We were operating this thing in bankruptcy for the court. So until recently, we did not have the right to develop this. We have been developing the plan through those 4 years in hopes that we would get the track. When we did get the track, we've immediately then started moving forward on our development plan. This is not some far-fetched plan that's going to be out somewhere way out in the future. We've already drilled 1 well. We're trying to get these 2 permitted so we can get them drilled. We've got a 4th well already permitted and ready to start drilling. And so we're well on our way. And these 2 wells are necessary for us to develop our plan.
Any other questions for this gentleman? Thank you, sir, very much. Mr. Box.
If I could briefly have Mr. Brittingham, like I said, we didn't get a copy of that, their map, so I would like him to come. He's spent some time looking at it and explain his position on it.
Just briefly, the bubble map, I think, is informative. My black and white copy shows the black areas where drilling, there's room to drill, if you will. As I understand, the 2 laterals, the French drains, if you will, the horizontal east-west laterals that are important for drainage, one is here and one is up here, and they're both going to be reached from a central 2 pads in the middle. One's going to go north and then west, the other's going to go south, then west. Well, their own map shows that they could put a surface location here at the terminus of this lateral and drill back to the east. Same thing here. They've got 2 surface locations. They can drill back to the east from here, notwithstanding using the existing locations to commence the surface. So their own map show that there's other places that these 2 laterals can be drilled.
And all I would add in closing is it was said again by opposing counsel that these 2 represent an optimal drilling site. And as this board knows, the optimal route is not what is required for a variance to be granted. Whether it's the Vinson case or the walking stick case, a self-created hardship, a financial hardship, is not a hardship. This board, time and time again, when someone comes up and will tell you why they want a variance, because it's expensive. You know, I don't want to pave, I don't want to do this, and the board knows. Financial hardship is not a hardship. We thank you for your patience in this long presentation. We would ask you to deny the variances sought by the applicant.
Thank you, Mr. Box. Mr. Lee, would you like to close?
Yes, sure. Notwithstanding what Mr. Brittingham said, and you can look at the exhibit yourself, the easterly edge of the unit is Western Avenue, right here. The thickest part of the reservoir is towards the center. It's clearly more efficient
for anyone, including Trey as the operator of the West Shore Junction Unit, to drill the wells as contemplated, not drill towards the edge of the unit, even if it were possible. Drill from thick to thin is not sound. Not only that, as Mr. Brittenham contemplates, we missed the lateral portions that extend on the easterly side, draining that portion of the reservoir. This is not a question of being optimum. It's the only way to capture those reserves, and without the variance, we'd be deprived of that opportunity.
I want to say a couple of things. When I first was going through my packet and came across this, I was so ready to jump on the protestants, because I have listened to this case for a long, long time, sitting on the Horseshoe at Planning Commission. And the issue of the surface development versus the mineral development is always the center of those issues, and it's always discussed. And I thought, boy, I'm just going to get them for this. But the truth is that in each of those instances, what was being discussed was the existing pad sites, and whether, the applicant for those rezoning and platting approvals was somehow subverting the ability to develop the hydrocarbons with respect to those existing pad sites. It was not discussed in terms of other additional future sites. And the applicant has always indicated that they understood that there was the right to develop the hydrocarbons, and that the development of the surface was subject to that and subject to the existing pad sites, and that even though they platted over them and rezoned them or whatever, that they could not interfere with the use of those sites. So I don't think that the position that they're taking here today is in any way inconsistent with the position that they've taken before the Planning Commission throughout the history of the cases for both rezoning and for platting, and I'm comfortable with that. And I didn't gotcha after all. So, and the other thing that I wanted to comment about was that there have been a number of times during the course of those hearings comments about the equipment, if that's quite the right word, that's underground, about what's under there, and about the fact that it is, in all probability, not in good shape, and that they really don't even know exactly where it is or what it is. And so with respect to that part of what Mr. Ham had to say, that is absolutely consistent with what has been said, not by the protestants here, but by the applicant here at those hearings. So I just wanted to share that with you.
Any other discussion?
It's difficult in a case like this to be able to respect all the parties' interest, and oil and gas is definitely a staple to the Oklahoma economy and the livelihood, but how we do that within cities and development is important. I think both parties, you can see passion on both sides of them articulating their viewpoint, and I think they should both be commended on a good presentation. And that's my comment to kind of what echo Janice's comments as well.
With respect to the merits of the case, I am not persuaded that these are the only sites from which these hydrocarbons can be extracted. I don't think that the statutory requirements for variance have been met here. I have a lot of questions in my own mind about the issues of seismicity, that's a new word for me, and about, the existence of the equipment underground and its viability. I don't know exactly how we would ever be assured maybe it would be a part of the variance and could be enforced in that way, but that there would be no fracturing on the site, or that there would be no disposal wells on the site. I don't know how in this process we would enforce that, but in any event, I do not believe that the statutory requirements for the variance have been met here. I am fully prepared to have whatever surface development of this property moves forward conditioned or existing, have it move forward around the existing pad sites and what's there now and what they have to allow for. And I think that they have made a plan for that and have provided for those contingencies. But I am not persuaded that this application should be approved.
Is that a motion?
I'll make a motion to deny it.
I agree. I don't think the application's met the statutory requirements, and I don't believe that the statutory requirements have been met, and I don't believe that the case law has been, so I'll second that motion.
Is this for both cases, 13-995 and 996?
Yes, we consolidated them. So I'll second the motion.
I have a motion and a second. Register your vote.
Motion is
To deny.
To deny. Oh, I'm sorry, I need to affirm my desire to deny. Okay. My light is burned out, but I am voting to deny the variance request.
Thank you.
Jeez.
That light is working in the night.
Item number 19, case number 13994, application for special exception of Trey Resources to allow a disposal well located at 4544 Southwest 134th Street.
And again, John Lee, I appear for Trey. I'm at 1800 Canyon Park Circle in Edmond. You have an unopposed application for special exception for a disposal well, which has been alluded to during the previous presentation. It is in a different township. It's over in Section 20, where we have received authority to drill producing oil and gas wells. The Corporation Commission has indicated no objection to it. We have an approved drilling permit. You heard from me earlier, speaking from the Commission's Underground Injection Control Department from Charles Lord, that they have no objection to it from the basis of seismicity. We'd ask authority, the granting of the special exception for the contemplated non-commercial disposal well.
Good afternoon. David Box, 522 Colcord Drive. We have not filed an objection on this, but we do want to state our objection on the record. It's our understanding that the need for this disposal well was contingent upon the two wells they proposed to drill that the variances were just denied. So we do want to state our objection to the disposal well based on all the evidence you heard on the previous two variance applications.
I think I'm going again.
Mr. Lee, Mr. Stonecipher's going to excuse himself.
This disposal well is in no way related to the variances you just denied. We need the disposal capacity for the existing wells that you have approved. So whether or not those wells are eventually approved has of no moment on our need for this disposal well.
Board members? Microphone.
Can we table this?
Would you entertain a continuance, sir?
Sure.
January the 22nd, February the 5th?
22nd January would be fine.
Motion for continuance to the 22nd.
Second.
A motion and a second, register your vote. We'll continue to the 22nd, sir.
Thank you.
We have one more matter, our sign to be parking garage.
Correct, Kathy. Would you call case number 13974?
Item number 5, case number 13974, request of Benjamin Shulaw for a variance to allow a sign encroaching the street right-of-way located at 431 West Main Street.
I really would like for somebody to come and talk to us about this. I mean, I realize it's our own deal, but
Let's continue to the 22nd.
let's do that.
Motion to continue to the 22nd.
Second.
I have a motion and a second. Register your vote.
Can we get somebody here, you think?
Sure, we'll see if Public Works or I'll call Mr. Shulaw.
Mr. Chairman, there being no further business before the board, I make a motion to dismiss.
Second.
I have a motion and a second. Register your vote. We are dismissed.